Now we will see Law of Treaties, second part. Treaty is a generic term to embrace all types of binding international agreements. In practice, a number of terms are used to indicate an international agreement. The term treaty itself is used to indicate formal agreements relating to peace, alliance, or the cession of treaty, extradition, or some other fundamental matter. Convention is a term used for a proper formal instrument of a multilateral character. A protocol is an instrument which is subsidiary or ancillary to a convention or is a supplementary treaty. An exchange of notes or of letters is an informal method very frequently adopted in recent years, whereby states reach to retain understanding or recognize certain obligation as binding upon them. Memorandum of understanding is now widespread in state practice that governments may use memorandum of understanding as more usual form, a treaty being used only when it cannot be avoided. The main reasons for using MOU in preference to treaties are confidentiality and convenience. As an MOU is not a treaty, there is as rule as no domestic or international requirement to publish it. Are MOUs treaty? Generally speaking, MOUs are not treaties. They are not legally binding. An MOU can be a treaty in some cases, but it cannot be in some other cases. Only by studying the terms of the instrument can only determine the genuine status. The decisive factor is whether there is an intention to create legal obligation. The actual practice of the state is to indicate their intention to conclude a treaty by employing terminology such as shall, agree, undertake, or enter into force. Oral undertaking. According to customary international law, writing is not an essential requirement of a treaty. An agreement or understanding made orally between two states is as valid as a written treaty. Legal status of Eastern Greenland, Denmark versus Norway, 1933. A territorial dispute between Denmark and Norway over Eastern Greenland during the official conversation between Norwegian Foreign Minister and the Danish Minister accredited to Norway. The Danish Minister suggested that Denmark would raise no objection to any claim Norway might want to make at the Paris Peace Conference at Spitsbergen if Norway would not oppose the Danish claim at the same conference to Greenland. Eastern Greenland. Mr. Elan, in the course of further conversation with the Danish minister, declared that the Norwegian government would not make any difficulty concerning the Danish claim. This is known as Elan Declaration. Denmark argued before the ICJ that this undertaking was binding upon Norway. It was held that the court considered it beyond all disputes that the reply of this nature given by Ministry of Foreign Affairs on behalf of his government in response to requests by the diplomatic representative of a foreign power in regard to the question falling within the province is binding upon the country to which the minister belongs. It was concluded that the treaty-making capacity and full powers, Article 7 says, in virtue of their function and without having to produce full powers, the following are considered as representing their state: head of the state, head of the government, ministers of foreign affairs, heads of diplomatic mission, adopting the text of the treaty between the accrediting state and the state to which they are accredited. Steps to be taken in making a treaty. The various steps in creation of treaty are negotiation, adoption, authentication of the treaty, expression of consent to be bound by the treaty, signature, ratification, assertion, entry into force, registration, and publication. When you see adoption and authentication, negotiation and adoption and authentication becomes very, very important. Consent to be bound by a treaty. Article 11 enumerates the way in which a state can express its consent: by signature, by exchange of instrument constituting a treaty, or by ratification, acceptance and approval, and by assertion. First we will see signature. The effect of the signature of a treaty. depends on whether or not the treaty is subjected to ratification. If the treaty is subjected to ratification, signature means no more than the authentication of its text. If the treaty is not subjected to ratification, it is silent on this point that the better option is that in the absence of contrary provision, the instrument is binding on the signature. Next comes ratification. A state requires an opportunity of re-examining the whole effect of the treaty upon their interests, may need to prepare public opinion, sometimes even referendum, for the obligation of the state is about to undertake. According to the constitutional law of many states, treaties are not valid without some kind of consent on the part of the parliament. Example, the US Constitution. Procedure for ratification. A document duly signed by the heads of the state concerned and or their secretaries of foreign affairs. Ratification involves two steps. The first step is the signing and sealing of the instrument of ratification.